uniqueness of our industry. And the second objective was certification and training. So we've just turned our recording on for everyone. So this session will be recorded today, and it will be available for you to go back to afterwards to review in case you want to take a look at some things that I said that confused you or wasn't clear, or if you had to step out temporarily. Jen will be sending out notices to you after the session's over with the link on how you can access the recording. Let's do this. I'm going to share my screen. So let's, excuse me while I click on all the right buttons. And we're going to share the screen for that one. And start up our slideshow from the beginning. And I know that I've asked everybody to come on mute, but I just want to double verify check. So if any one of you, including Jen or someone else, can just verify for me that you can see the screen that's up there now. It says Legal Aspects Staffing Services CPC module.
There. Yep.
All right, good. I once started to do this thing and realized that my screen was frozen, and I was 10 minutes into it before anyone notified me that I was confusing the heck out of everyone. So thank you very much for that. Okay, so today we're going to talk about legal aspects of staffing services. Because of the time of year, I know that for most of you, this is probably your first CPC session, which is means that we're beginning our new year. There will be, as we move through the year, more CPC sessions, including this one, Legal Aspects for Staffing. There will be a health and safety module. There'll be legal aspects for recruitment. I think next week is business practices and ethics. And later on in the year, we're going to be adding in, sorry, I'm going to go backwards. Later on in the year, we're going to be adding in another one for sales, which is not mandatory, but it's optional. And it will go towards your CPC credits. So if you want to join in that one, keep your eyes open. And I'm just trying to shorten that session up a little bit. I think it's going to run a little bit longer than 3 hours right now. So we're going to try to shorten that one up. The CPC is the only certified professional designation that is available in Canada for people working in the recruitment and staffing services industry. Of course, you can get your designations through human resources organizations, and you can get diplomas from and degrees from university. But this is the only one that is specifically designated towards third-party recruiters and staffing consultants working in the staffing services industry. At the end of the sessions, when this group is over, there will be a CPC challenge exam. If I remember correctly, if I'm not wrong now, it is a multiple guess examination. I'm going to emphasize this probably over and over again. It's not important that you memorize really super specific details. So if I tell you today that overtime is calculated in a particular province after 8 hours in one day, and double time 12 hours on another day, and 44 hours in another province per week, and 88 hours in hours averaging in another province, it's not important that you memorize your province or any province's specific details to that degree. You can always look that up, and those things change. And so with changes in legislation and regulation, so I always encourage people to go look it up anyways. The important thing is that you understand the concepts and the principles of what we're going to talk about today, so that when the issues do arise for you, you know that you do need to look it up. You know that it is an issue. You know that it is something that is covered under specific legislation, and you know which legislation to go look for it under. So there are some questions that are pretty high level about some details, but most of the time when it gets down to things like how to calculate, you know, a notice of termination or weeks of vacation or calculation of pay, they're going to ask you that they exist. They're going to ask you when they exist, why they exist. They're probably not going to ask you to do they're not going to ask you in the multiple guess questions to do the calculations or provide that kind of detail. The everyone who's on the line today is a employee of, owner, manager, or employee of an ACSESS member company. Companies belong to our industry association, not individuals. And so as an employee of a member company, you have access to all the rights and privileges of the member company in terms of things like CPC and the resources that are available through the association, and to participate in chapter events and also in annual conferences at member rates. The each member company, when they make the application, makes a commitment to uphold the code of ethics and standards for the industry association. And we have a mission statement, which is to identify and communicate and monitor industry standards and ethical business practices on behalf of the recruitment and staffing industry, to positively influence and protect the regulatory and business environment that impacts our members and the people that we serve. And this is really important, this particular aspect of it, and it's the topic, obviously, of our session today. This one is really important because of the unique nature of our employment relationships and not employment relationships. So we're not the employer when we're acting as a recruiter, a third-party recruiter, to do search and placement, but we're acting on behalf of a company. And so any regulations that might affect the company, the employer, wouldn't affect us. And so we want to make sure that we have proper regulations and legislation that is appropriate for the nature of the relationship that we have with the candidates and with our customers. And in terms of temporary help, we are the employer of record, and yet we're sending our employees to go work in another company's workplace where they have a significant degree over things like safety in the workplace and rules and policies. And so again, normal legislation that would apply to a traditional employer who has a place of work and people come to that place of work wouldn't necessarily apply appropriately to us because we're an employer over here sending our employees to go work over there. And so we want to make sure that the regulations, policies, and legislation that exists in the marketplace reflects the uniqueness of our relationship with those workers and with those customers. One of our mission statement objectives is to promote credibility and visibility of the industry and to the business community for governments and public and the general public. So this is to help us grow. And the industry is one of the fastest growing industries in North America and in the world. And we continue to be that because we continue to tell the right stories to the community, to the public, to businesses, and to government. And they understand our role that we play. And we want to provide our members with strategic support services, programs, and tools like the CPC. But there are also other tools available to you through the ACSESS office. And finally, before I move on to the next screen, I'm going to suggest to you that if you're new to CPC, you probably don't have a login. Your company does, and a representative from your company does, but you probably don't yet have a login for member to the member services area of the ACSESS website, access.org. So sometime in the next little while, today, tomorrow, next week, send an email to Jen, who registered you for your session today. Ask her to set you up as a member. She'll send you a link and a temporary password, and you can log in, and then you will have be able to access the ACSESS member services area and take a look at all the other services that are available to us, including things like schedules for conference and for chapter meetings and other materials that are available in terms of brochures and so on. Now, every member company, when they join ACSESS, makes a commitment to uphold the ACSESS Code of Ethics and Standards. And so, you know, besides the fact that we want to know that you're in good standings with the government and with your taxes, and that you have, you know, your company's owners have no criminal backgrounds and records and so on, we also want to make sure that we have made a commitment, that each of our members have made a commitment to our code of ethics. And so I'm just going to read this to you. It says, as a member of the Association of Canadian Search and Employment Staffing Services, we commit to uphold this code of ethics and standards and to display it prominently in our place of work. We support the principles set forth below and acknowledge that compliance with these principles is in the best interest of ACSESS member companies, their candidates, employees, client organizations and the reputation of the search, employment, and staffing services industry in Canada. And so we're going to take a look at what those what that code of ethics is, and we're going to talk about it a little bit in the ethics session that is next week. Today, we're going to focus mostly entirely on the legal aspects of the staffing services industry, with a lot of emphasis on provincial employment standards. We're going to talk a little bit about this notion of co-employment, and we're going to talk about some of the liability issues that exist with respect to the determination of the status of a worker as an employee or an independent contractor. We're going to talk a little bit about how these things affect us in our business every day. And of course, we're going to make a commitment to live by the things that we learn here in this session, and things that affect our commitment to legislation and ethics. So first off, we're going to talk a little bit about employment standards legislation. And, you know, when we're often, this is where we sort of take a little break and we talk. Sorry guys if I look like I'm moving things around on my screen so I can see what I'm showing you. This is where we often take a little break and we have a conversation about what people do and what people know, and we try to get a sense for who's in the room, and we get a starting point. We're going to assume for today's purposes that you, every member online today, knows absolutely nothing. And we're going to move forward. Although I do want to say this, that I was doing a consulting session with a client as recently as this morning, and we were reviewing some of the stuff. And while the individual that I was working with is a professional, competent, educated, master's degree, he's new to Canada. And a lot of the terminology that I was using, things like Charter of Rights and Freedoms, and talking about appellate courts and common law. These were expressions that are not common to this gentleman. And he's a quick learner, but I had to move through some of these things a lot slower than we're going to go through today. So if I do go too quickly for you today and you don't get a chance to ask me during the session, please feel free afterwards to send me an email. I'm going to give you our email address, my email address, and you can send the question to me, and I will answer it for you. I will send a copy of the answer also to Jen. And if the question looks broad enough and interesting enough and the answer for everyone, then you might get a few emails over the next couple of weeks and see the answers to questions that you didn't ask that someone else put forward to us. Why is it important to know the law? Well, we want we want to know the law so that knowledge will help us to educate our customers. I mean, I think we're way better at selling, doing better business, keeping our customers and retaining our customers when we're able to act as an advisor and a consultant to them, not only just a supplier, but a really informed, educated, helpful supplier who helps them in all aspects of their business. We want to protect your employees, particularly your temporary employees, and you, when you're doing your work, to ensure that you receive at least the minimum entitlements that are available in the provinces. By the way, we're also going to emphasize a lot today when I talk about the provinces on Ontario, just because the majority of the people in the room here, as just reflecting the population of the country, are from Ontario, but I am going to bounce out from time to time and give you examples for Alberta or Quebec or British Columbia or Saskatchewan, Manitoba. Give you a few examples just to show you that these things do change from province to province, and to give you some perspective. We want to improve our productivity by eliminating misunderstandings and problems. So we become great suppliers and good actors in the industry when we understand what we're doing and we do it right the first time. I talk a lot about exceptions, and we know that if it takes 5 units of work in order to get 5 things done, but one thing goes wrong, it can sometimes take 5 more units of work in order to fix that one thing. So we end up doing 10 units of work in order to get 5 things done. And the way to be really efficient in work is to get things done right the first time, and not have to deal with exceptions. So we want to eliminate any misunderstandings and problems to improve our productivity. We want to protect your professional reputation and limit your liabilities, as well as the liabilities and the professional reputation of our clients and even our competitors. When one actor acts badly in our industry, it reflects poorly upon all of us. We want to earn respect and dedication from your clients, who will rely on you to do things well, to do things right, to do things legally, and to give them advice on how to do it that way also. We want to differentiate you from other companies in the marketplace. And there are literally thousands of companies, about 6,000, I don't know the number anymore. I think it's around 6,000 staffing companies in Canada that are actively supplying temporary help and doing recruitment. I can't even count for you the number of independent consultants that are doing recruitment across the country. And while you have a professional designation and you have made a commitment to your industry, to your knowledge, and to your professionalism, you easily differentiate yourself from some of the others who have not done so. We want you to help retain your workforce. Turnover in the temporary help world and in the contract world is a terrible cost of doing business. Recruiting the same person twice, fulfilling guarantees because you had fall-offs and no-shows and all kinds of things in the search business. These are all things that we want to try to improve as a result of being professionals. And of course, we just, in a big, broad sense, want to adhere to the code of ethics and standards in the industry. So first off, we're going to talk a little bit about the 4 aspects of law in Canada. And we're going to do this in a real broad sense. This isn't a, Law 101 university course, but it's important to understand that we've got really 4 ways to look at the laws and how they're created and how they're managed here in Canada. The first is constitutional law. We've got the Canadian Constitution, and within that, the Charter of Rights and Freedoms. And of course, that's, for those of you who know your history, that came as a result of the change from the BNA Act. It evolved, and eventually we created the Canadian Constitution, and the Charter of Rights and Freedoms. And I like to, in a real kind of common sense way, say that the Charter of Rights and Freedoms and the Canadian Constitution are the laws about laws in Canada. In other words, it's the Constitution in Canada that designates who has authority to make laws about certain topics. So it designates which things are of federal jurisdiction and which are of provincial jurisdiction, which topics are of provincial jurisdiction and which topics are of federal jurisdiction. And of course, the Charter of Rights and Freedoms tries to help create a balance to provide the freedoms to each individual with respect to their privacy and their individual rights, so that they can't be overwhelmed by a government that makes laws that are overly zealous. And so our Canadian Constitution is the law that stipulates how other laws must be created and what categories they cover and who has authority over making those laws. And so sometimes we talk about a charter challenge or a constitutional challenge or something going to the Supreme Court. And this is when people are arguing that some law or some decision or something that's happened in the lower courts or down the way maybe are not consistent with the law about laws, about the Canadian Constitution. The second types of laws we have are what we will refer to generally as statute laws. These are regulations and legislation that are created by members of Parliament federally and of the various legislatures across the provincial governments in Canada. And of course, even some municipalities have the rights to determine laws about things like the size of properties on land and what your sidewalks are supposed to look like and how much ground your driveway can cover and the size of houses and parking violations. So cities can, through their city councils, can create statutes or laws. Provinces can create laws. Employment legislation is significant. Anything to do with, say, for example, the Highway Traffic Act and criminal offenses and certain kinds of taxes. These are all political decisions decided by our members of the legislatures or Parliament that are put forth in the form of a bill that are then debated and voted on and the majority in our legislatures create these laws. Very often we have laws like the Employment Standards Act in each province, and they have they have Labor and Standards Act, to provide different names for exactly the same types of laws in different provinces, but every province has an employment standards legislation. And we often have amendments to those laws also passed by your provincial legislations. So things like minimum wage, which are originally part of the Employment Standards Act. And then as time goes on, the members of your legislature, provincial government, decide that it needs to be upgraded. And so they pass a law that is an amendment to an existing law. And then we've got this thing called common law. And most of us are familiar with the term common law when it comes with respect to, say, for example, a marriage. There was this notion of people first originally in your province. If you wanted to get married, you went and got a marriage license, and it was only legal for a certain, like a judge or a particular member of a minister or religious leader would have the right in order to sign a marriage license to verify that you were in fact married. And then along came this principle of people living together for 4, 5, 6, 7, 10 years, and things would happen. They'd want to split up. They would like to divide their assets. Somebody would die, and there would be a will. There would be children involved. There would be home ownership, and eventually people would go to court and say, "Yeah, but we're kind of married. Like, we've been acting like we've married for a whole bunch of years." And so the notion in marital common law came into existence, where after two people lived together in the same household and lived like they were married, I think originally it was 5 years, now in some provinces it's 2 years, that you would be considered to be married under common law, which means there's no legislation, which means it didn't pass a statute in the legislature or in the House of Commons. It meant that certain things existed through common sense. We would say, yeah, these are the common laws that apply to all people, regardless of whether or not the legislature could contemplate writing it down. And very often common laws are created through court precedences. So very unique circumstances exist, and it goes to court and people sue each other, or they have a disagreement over something, and a judge makes a decision, and then that becomes what is often referred to as a precedent or common law. In other words, if the exact same circumstances applied to two people or two parties again in the future, and they were exactly the same circumstances, and if the judge was correct in applying their understanding of the laws to the previous case, then in this case, the same law would be common to them. So this is what we refer to as common law. And then finally, we have contract law. And contract law is when you hear about people suing each other or unlawful dismissal. This is when two parties have a contract, whether it's a contract to purchase something or to lease something, or an employment agreement or a recruitment services contract agreement, that we have two parties who have agreed to terms of an agreement. And those terms literally become the law between those two parties. And if one party breaches the terms of the agreement, they have violated the contract law. And that's why we get to go to court, again, using judges in our legal system to determine who was right and who was wrong, and to decide how this is all going to work. And of course, in that contract law and in statute law, we've got this sort of combination of things like, if you violate a law, you have to go to court and you have to defend yourself, or maybe charged with something, and it could be an employment or workplace safety legislation or something like that. So we've got constitutional law, the law of laws. We've got statute laws, those that are written by our members of parliament and legislature, by elected individuals. Those are political decisions that are intended to be in the best interests of society. We've got common law, which are those common sense things that exist for all of us, even though they may not be written down somewhere and probably were decided somewhere before by a judge for the exact same circumstances. And of course, we've got contract law, which are the agreements that we sign between each other in order to hold each other accountable for our parts of the agreement. Now, in Canada, we've got through our Constitution, we decide which industries are going to be regulated by federal legislation, by the federal government in Ottawa, and which industries are going to be regulated by our provincial governments. Now, it specifically talks about things like education and health being the responsibility of the provincial governments, but more so in the Constitution, it talks about what industries are regulated by the federal government, and everything else that's not listed as a federally regulated industry falls under the authority of provincial governments. So we talk about banks. Of course, we want our banks to be federally regulated because we'd like to have the same standards across the country. And if you put money into a bank in British Columbia and you withdraw it in Nova Scotia, you'd like to know that the same rules exist with respect to the protection of your money and the rules about how your bank is going to work. And so our banks, which are interprovincial, are regulated by the federal government. Our marine and shipping, those things particularly that come from the ocean or go into a waterway that attaches directly to the ocean, our ferries and ports and services, those are all regulated by the federal government. And of course, that's because the government wants to set a standard so that when things arrive in Canada, it is the same standards that they arrive in the Yukon as they would as if they arrived in Nova Scotia. We don't want to have people having different rules, and so importing things and doing things and bringing things into the country with different tax levels and tariffs just because of the port that they happen to select along the coast of Canada. Air transportation, same thing. Of course, airplanes go up in the air and they cross over provincial rules. We want to have a consistent standard across the board, and particularly because we're also affecting airlines and airplanes that are coming in from other countries. So we can't have every province deciding what the rules are going to be along air transportation. Same thing goes with things that cross borders, interprovincial railways. We can have trucking companies that are only in one province. They would be regulated by provincial governments. And if they're intra-provincial trucking companies that cross over borders, then they would be regulated under federal legislation. Now, I'm going to tell you a little story. I know of a company, at least one, in the province of Quebec that didn't like some of the legislation that the Quebec government was imposing upon staffing companies that were in the trucking business, supplying truck drivers. And so they started supplying people and delivering goods and so on across borders so that they went and got business in Ontario and New Brunswick. And so now they could be federally regulated. And so now they don't apply to the provincial legislation. They have to apply to the federal legislation, which in their particular case, in that particular set of issues, was less onerous. And so they organized their company in such a way that they would apply to federal legislation instead of provincial legislation. So there's a little side story. Of course, the CRTC, the television, radio, cable, CRTC, Radio Television Commission. CRTC is a federal body that regulates our internet and our telephone companies and our cable and our radio, television channels, things that fly through the airways, because of course, things that fly through the airways and go onto the internet do not have provincial borders. And so again, that's federally regulated. Grain was originally considered to be one of the tentaments of the Canadian economy. And of course, grain is grown in the prairie provinces and then distributed across Canada. And so grain elevators, feed and seed mills are regulated by the federal government. Uranium, for safety reasons, of course. Protections of fisheries and natural resources. If the waterway connects to the ocean, then it falls under the federal fisheries protection rules. And if it is landlocked, like a small lake in your province where your cottage is, then that would be provincially regulated for fishing and so on. Many of the First Nations activities are regulated under the federal government. And so these treaties and things that we hear about all the time, those are almost always federally negotiated, which doesn't, by the way, stop a provincial government from entering into some kind of an agreement about something like a casino on Native land and operated by Native groups. But the higher overarching rules with respect to those relationships are the federal government. Of course, all federal crown corporations like the CRTC and federal prisons and other things that are federally regulated, the FCC. Those are all federal crown corporations and special operating agencies that are regulated by the provincial government. And there's also sometimes some private industries that the only thing they do is serve an industry that is federally regulated. So let's say, for example, the only thing you did was, I don't even know if this is accurate, but if the only thing you did was provide a service to lobster fishermen, fisher people, and that's the only thing you did, then you would vicariously be responsible for under the federal legislation, because you would be deemed to be in the federal fisheries industry, not in the repair of nets industry, so to speak. So, so we've got provincial legislation, each for every other industry. So staffing services, temporary help companies, 90% of all of your customers who operate call centers and oil and gas and forestry and manufacturing and automobile manufacturing. These are all things that are regulated by provincial legislation. And each province has its own Employment Standards Code or regulation, or Employment Standards Act. Sometimes the name changes a tiny little bit from province to province. They're not all called employment standards. Some are called labor standards. But, you know, incidentally, on the province of Ontario, we talk about our Labor Standards Act, which has to do with union agreements, and employment standards has to do with everybody else. And so we do have some subtleties in the name changes, and they can mean something sometimes. So these jurisdictional issues can be of significant issue to you and can be confusing for you. And so the example might be that a temporary staffing services agency located in the city of Ottawa, in the province of Ontario, near the border of Quebec, may be supplying temporary workers across the border to Place de Portage, which is in the city of Hull in the province of Quebec. So now what we've got is a federally regulated customer operating in the province of Quebec, being supplied employees from an Ontario-based company. And quite frankly, the employees might be residents of the province of Quebec. So we could have a person who we employ who lives in Quebec, works in Quebec, but works at a federally regulated company, but being supplied by an Ontario-regulated organization. So of course, this means that now we've got the families, their schools are closed on Saint Jean Baptiste Day, but the Ontario company's not closed on Saint Jean Baptiste Day, and the federal government doesn't recognize Saint Jean Baptiste Day, so it's not closed down on that day. So we've got a lot of confusion going on. And the important thing to remember from the highest level is that it doesn't matter where your employee lives. It doesn't matter what industry your customer is in. It doesn't matter what province your customer operates in. What matters is what province you as a staffing service work in, and the location of the office that you work from or through. So this very complicated scenario that I gave you with respect to working in Ontario, providing to Quebec, to a federal government, the answer will always be, it's an Ontario regulated company because they're registered in the province of Ontario and they're working from or through a location in Ontario, and it doesn't matter where the employee lives or where the customer is located or what jurisdiction the customer is regulated under. We also have this issue of employee versus independent contractor, and I think you might have been sent a document that I created a bunch of years ago with respect to the determination of an employee versus an independent contractor status. And we're going to come back to that in more detail later on, but I just want to kind of emphasize this, that a worker of a company is always an employee of the company unless they're not. Now, that sounds ridiculous, doesn't it? What it means is that When a company employs individuals to work on their behalf, they automatically default as an employee of that company, and all employment legislation that exists in that province is applicable to the relationship between the company and the worker through an employer-employee relationship, unless both parties can absolutely establish that a real independent contractor relationship exists. So, for example, I own several companies. I work out of my house. I own several, most of the time. I own several companies, and I would be considered an independent contractor, or my companies would be considered independent contractors. But we do a lot of work for the same organizations over and over and over again. I can prove that I'm incorporated, that we work off-site, that we have many customers, that we pay our taxes as a company, that we operate as a company, that we don't rely upon, we're not under direction, control, and supervision of those companies. But when you get to be in the temporary services industry, or when you're recruiting permanent employees on behalf of another customer, it's sometimes the circumstances are not so obvious. And so the reality is that in most provinces, and particularly in statute written into the law in the province of Ontario, an employee is a worker is the employee of the temporary staffing service, unless you can absolutely prove, both parties can absolutely prove, that you meet the conditions of an independent contractor relationship. And it is illegal for an employer, or for a company, or for a staffing service, or for a customer to arbitrarily designate a person to be an independent contractor when they otherwise would have looked, smelled, and tasted like every other employee. So we're going to talk about some of the things that are covered under these Employment Standards Acts or labor codes in various provinces, remembering that the federal government has its law for its federally regulated industries and companies, and for the federal government, and each province has their own Employment Standards Act, often referred to as an ESA. In Ontario, it's often referred to as the ESA 2000 because it was entirely overwritten or significantly rewritten in 2000. But amendments are made to Employment Standards Act almost annually in every province for something. So we talk about things like posters and the distribution of information to make sure that your employees understand what their rights are under the law. So it's an obligation under the law to make sure that we share the laws accurately with our employees. Things like hours of work, eating periods, rest periods, time off, those things are all written into the law with minimum standards. We talk about the payment of wages, and those payment of wages, we'll talk things about the frequency of wages, how they're to be paid, who they're to be paid to. There are minimum standards in the laws concerning that. Things like overtime pay, whether a person gets paid over 44 hours or over 12 hours a day, or whatever the rules would be. Each province has its own laws and regulations concerning overtime pay. There are special laws in some provinces concerning how tips and gratuities are supposed to be handled. Of course, minimum wage, I've already mentioned that. We showed an example of minimum wage previously in the provinces. And so minimum wage is something that you hear about all the time. The federal government has a different minimum wage than each individual province has. So in fact, you could be working in the province of Saskatchewan and have a $14 minimum wage if you work for a provincially regulated company, and the federal minimum wage of $15.50 or whatever it is, $15.50, I think, if you worked for a prison and made minimum wage, or you worked for an airline or a telecommunications company, then the minimum wage in those companies in Saskatchewan would be $15.50. So it matters what industry you're in and which law will apply to you. Every province has varying degrees of different types of leaves. Leaves do not, when we talk about a leave under employment standards, we don't talk about paid time off, although we'll call those holidays and vacation. But leave is a person's right to not come to work because something happened and that they're not of risk of losing their job. So we've got pregnancy leave. That's an obvious one. Person is pregnant and they get to have a certain amount of time off. And the federal government determines how much time a person can maybe receive pregnancy benefits under employment insurance program, but the employment insurance program is a federally regulated issue, whereas the leave, the amount of time you're allowed to take off, is provincial. So the federal government might say, hey, you're entitled to 6 months or 1 year or whatever of pay. That's employment standards. That's the, unemployment insurance or employment insurance legislation, federal, for all people all across Canada. And pregnancy leave is provincial. So those two time periods could be different. You might be entitled to 6 months worth of benefits under EI and 1 year of leave under pregnancy leave. Now, I'm going to jump into a different same topic when I mention pregnancy leave, because this is very common. It's very common that a company will have, very, very, very common, that a company will have a higher standard in their policies than exist in the minimum standards under the Employment Standards Act. So a company is not obliged to only provide the benefit that is stipulated in the Employment Standards Act. The company is only obliged to never go below the minimum that is set by the Employment Standards Act. So these are minimum standards, and of course, a company, an employer can exceed those standards at any time. So there are different kinds of leaves: personal emergency leave, family caregiver leave, family medical leave, critical illness leave. There's even leaves for child disappearance and abduction leave. So we know that, there's death of a family member leave. So each one of these different types of leaves are defined somewhat differently in each province, but they determine how much time a person is entitled to take off under certain circumstances without ever being at risk of losing their employment. Now, there's other kinds of times off. Of course, there's public holidays in the province of Ontario. For example, it's different than the province of Alberta and the province of Quebec. Some provinces are more similar to the federal legislation than they are to other provinces. Things like Remembrance Day are holidays, I don't know, in Alberta, I know that for a fact, and it's a holiday, a public holiday for federally regulated industries, but it's not a provincially regulated holiday in the province of Ontario. So this is why we often refer to things like Remembrance Day as a bank holiday. This is a colloquial term that explains why the bank is closed on Remembrance Day, because the bank is a federally regulated organization, banking, federally regulated, operating in a province like Ontario, doesn't have to apply to the provincial legislation. The province's schools are open and businesses are open on Remembrance Day in Ontario, but the banks are closed. And so what did we do? We said, oh, the banks are closed because it's a bank holiday. Well, that was our simplistic way of saying it's not really a bank holiday. It's a federally regulated industry holiday. And so all airlines and so on all have to treat that as a holiday. Now, of course, airlines don't close on holidays. They pay people time and a half and give people days off in lieu, because we can't close down some of those services on holidays. So they've got special rules about how they give people days off in lieu, and how they've got double time and triple time and things that they do to accommodate facts that people might be working on public holidays. We've got rules concerning our vacation and how much vacation an individual is entitled to, usually with respect to the tenure, the length of their employment. And again, different for federally regulated and different in each province. We've got hours of work, how often you get breaks, whether you get lunch or coffee breaks and so on, how many hours are maximum in a work week and in a work day. We've got rules about termination of employment. And if you decide to fire an employee, how much notice and severance you must give them, or how much pay in lieu of notice and severance you must give them, and what constitutes willful neglect, and what constitutes cause for dismissal. These are all things that are written into Employment Standards Act. Most Employment Standards Act have things called equal pay for equal work, which has to do with gender differences, that men and women doing substantially the same work in the same location, performing jobs with the same amount of tenure, get paid the same amount of money. In the province of Ontario, there is a whole section in the Employment Standards Act that is specific only to temporary service agencies or temporary help agencies. And they define a temporary help agency, and they define a client, and they define a worker, and they talk about the obligations, and we're going to go into some of that today. And there's often things about compliance, about what happens if you break a rule and how it is enforced. The minimum wage legislation, here's an example of the current minimum wages in Canada. You can see that, for example, the province of Saskatchewan is $14. Federal legislation, which I think is at the bottom of the screen, which I can't see right now because there's something in the way. It doesn't say there. I think is $15.50, I think is for federal government. Province of Ontario, $16.55. Interestingly enough, Manitoba, just 2 days ago, had an increase in their minimum wage to $15.30. And that was the second increase in minimum wage in the province of Manitoba in 2023. How could that happen? Well, what happens is that, let's see if I can get us to another screen here. So Manitoba had an annual adjustment based on their consumer price index or on inflation. And so what happened was, what happens often, is that provincial governments pass a law often related to and around before or after an election. So sometimes something political parties do before an election because they think it's going to help them get elected. Sometimes it's part of a political campaign that they say if they get elected, they'll do this after they get elected. And sometimes it's just under pressure that, they feel that it's got to, they need to change the minimum wage in their province. And very often, provincial governments will pass a law that says we're something like Ontario did under the Liberal Win government. They said we're going to add $1 a year every year for a certain number of years. So people can project and plan on what the costs would be for their businesses and what their income would be going forward. And of course, 7 years ago or 6 years ago or whatever it was, when the Ford government was elected, they ran on a campaign that they would cancel those laws and they would reintroduce different kinds of laws that were associated to the cost of living. So instead of having a fixed increase in dollars, they would tie it somehow to the cost of living. So interesting enough, what happened in Manitoba was that a couple of years ago, they passed a law that said for the next number of years, I think until next 2024, they would tie together the cost of living, the CPI, to the minimum wage. And if there was a certain differential in percentage, then that would trigger an increase in the minimum wage. Well, inflation was so significant over the course of the last year and a half, it actually hit the minimum and triggered two changes in the province of Manitoba to increase their minimum wage there. So the process for minimum wage is decided politically through our legislatures, often in a multi-year decision that is sometimes associated to consumer price index or inflation, or their fixed numbers. And they're often, because they are political decisions, can be unraveled or canceled or changes with changes in government, or improved with changes in government. And there is no law whatsoever that says how often a minimum wage must be increased. It's a political decision. And there are some implications with respect to lower and higher minimum wage. And I think I sort of follow the sort of, interpersonally, follow the sort of general thinking that minimum wages that are way too high are hurtful. Minimum wages that are way too low are hurtful. And what is way too high? If it's far too high, far might be debatable, but might be obvious. Far too low might be debatable, but probably obvious. And so what we do is we end up having this political decision about what's the threshold. What do we have as an obligation as a society? What role does government have in influencing business? And I think that we can say that I know that we can say that there are thousands of studies that have been done of the impact of the minimum wage on the economy and on businesses. And we know that certain countries that have got no minimum wage or very low wages, that business over the course of the last several decades have gone to China and India and other places where the wage cost is significantly lower. And that creates a whole new set of problems with respect to the exploitation of workers and our personal views. And we know that some industries like Ford here in Canada, the union agreement that they just signed has got significantly higher wages than they had before and than the average for similar types of work. And they're a highly successful company. And so higher wages tend to have an implication on retention, employee satisfaction, retention, the call rate turnover, the quality of workers, performance of workers, on attendance and participation. So higher wages tend to have very significant positive influences. And of course, I think lots of companies can tell you that, wage costs drove them out of business, that some companies paid too much money and they didn't get those benefits and they couldn't compete for various reasons that probably didn't have as much to do with wages as it did to do with their product or their service or their management. But companies are trying to find that magical number. And we know that wages are minimum wages affect other wages. So when minimum wage goes up, usually the job just above it goes up, and then the job just above it goes up. And as we get further and further away, it probably has less and less impact. So when we increase minimum wage by $1, Elon Musk's salary doesn't go up by $1, but probably the person who has the job just above the minimum wage job that they aspired to get, and the supervisor of that person they aspired to get, we probably see some influences that are pervasive in pushing wages up generally through that area. And so we see that minimum wages have impacts on companies and on performance and on other wages, and of course on, therefore, cost of living and inflation. And it's the obligation of our legislatures to try to balance what's the right answer, what's the right number that is best for people, best for companies, best for our economy, and best for our conscience. There are minimum wage industries, certain jobs, food services, I think, has a different minimum wage. Kids under the age of 16 have a different minimum wage. So there are certain circumstances where in Ontario, they had minimum wages set for caregivers, especially during pandemic. They had temporary minimum wages for caregivers, and so on. So minimum wages are political. They're decided by legislature, and there's lots of influencing factors. With respect to the payroll and these wages, employment standards often will always set out rules around pay periods. So they tell you have to have pay periods. They have to be regular. They have to be known. You can't decide, we're going to pay people on once a week now, and then 2 weeks later, we don't have enough money, so we're going to delay it, and then they get more money, so we're going to pay people this week. You have to have, by law, regular pay periods, and they have to be properly communicated in people's employment agreements. Direct deposit must be paid to the name of the employee, so it can't be paid to a person's child or wife or someone else who might want to affect tax implications or can't prove that the money was paid. So direct deposits have to be paid to the name of the worker. So it doesn't mean you can't have a joint account, so long as one of the names on that joint account, husband and wife, for example, is on the account. We have to have a wage statement. So a pay stub, in the case of a written check, has to specify the breakdown and how that money was earned and when it was earned. And a wage statement electronically for electronic funds transfer for people who are paid automatically in their bank for direct deposit. We have to give them some access to either online log into a portal or email their stubs to them or something, but wage statements are a requirement under Employment Standards Act. We can not just arbitrarily decide that somebody owes us money and deduct money from somebody's check. It has to be done through, unless it's a legislated deduction like unemployment insurance, Canada Pension Plan, or taxes, then we have to have, or unless we have a collective agreement like a union for union deductions, or if we've got an employment contract for benefits where maybe the company pays 50% and the employee pays 50%, but you cannot just arbitrarily decide to deduct something that you think the employee owes you unless you have a court order. So a court order usually is what is referred to as garnishment of wages. And that could happen, say, for example, someone who didn't pay their credit cards or pay off their car or make their mortgage payments. The bank or the lender could go to court and make application for a court order to get a garnishment of wages, which instructs the employer to withhold that money and pay a certain amount of money to the other party. There are statutory deductions, which I mentioned, CPP, tax, EI, and we obviously can pay people vacation pay. We can pay it usually in most regular employment. We accrue our vacation and we save it up, and then we get paid vacation when we take our vacation. So it comes out of our bank, so to speak, and paid to us when we are on our vacation. Or in the case of some, say, for example, temporary help companies, you might enter into an agreement with the employee that you pay them on each check, because they come and go and start and stop. It's very difficult to keep control over when they're actually on vacation and when they're on layoff and when they've gone to work for somebody else. And so you can have an employment agreement that has vacation pay paid out on each check. But the legislated default is that it is accrued and withheld and paid at the time when the vacation is taken. And we have the right to sign agreements that are at least as good or better than what is in the minimum standards by law. If you want to have other payroll deductions, they have to be written and authorized. They're not permitted to cover the cost of faulty work. You can't say, oh, you lost my hammer, I'm going to make you pay for that on your check. And when it comes to things like cash shortages, the only time you can even have it written into an agreement that an employee would be responsible for cash shortages is if the person is responsible for their own signed and authorized cash register. So you could have a drawer, for example, you hand the person their $300 float at the beginning of their shift, and at the end of the shift, they have to hand in their receipts and the money. So they show, oh yeah, I started with 3, I sold 4, there's 700, here's my $700. If no one else had any authority to touch that cash box, it is legal in most provinces for you to tie together the fact that they owe you that money. But of course, most companies don't do that, and that's not the way most things work. Most cash registers are accessible by many people. So it might apply to like a nighttime gas station attendant or something like that, who's all by themselves locked in a room and nobody else can come in there. It is illegal in most provinces, and it's written into the law in Ontario that you cannot charge a fee to a worker, to a agency candidate, not to help you find a perm job, not to help you find a temp job, not to redo your resume or to give you coaching services. That is illegal in the province of Ontario, and that falls under the part of the legislation that specifically identifies temporary staffing companies. Every Employment Standards Act has hours of work, and I'm going to give you some examples. So, for example, in the province of Ontario, unless you have a contract that specifies otherwise, you cannot legally require a person to work more than 8 hours per day. And all that means is that you can say your contract is for 8 hours a day, and if they want to leave at 7, you could say, no, you got to stay till 8. And if you don't stay till 8, I'll fire you. And you can have some leeway with respect to that. But if you want them to stay longer than 8 and it's not written into their contract that they will, then you can't legally require people to work beyond that. You can't legally require people in the province of Ontario. Every province is different. Remember, look it up. We can't legally require a person to work more than 48 hours per week. And it is generally illegal to have people working regularly beyond 60 hours per week. So you can ask people to work up to 48, but not require them to work beyond that. And you can't even ask people to work beyond 60 hours a week in Ontario. Now, there are some special provisions and there are permits and there are things. So, for example, we have this thing in Ontario and in one of my companies where we're in the healthcare business, we have special rules with respect to hours averaging. So we can have people work 88 hours in a 2-week period, not 44 hours in a week, for example, for overtime. So, but it still doesn't change the fact that we can't ask people to work more than 60 hours in a week. People can, they do, but we have no right whatsoever to require a person to do that. So in most cases, there's a time period that a person must receive in between shifts. And so if you send somebody home at the end of a shift, you can't start their next shift 4 hours later or something like that. And there is also minimum requirements with respect to how much time people have off in a week or in a period. So for example, in vacation in the province of Ontario, you must give a person 1 day off every 7-day period. And that has to be 24 consecutive hours within a 7-day period. We give 2 weeks generally. We give 2 days off every weekend generally for people, but it's not uncommon to say, for example, to work for a nurse, to work 4 12-hour shifts 1 week and 3 12-hour shifts the next week. So they worked 7 days off in a 2-week period. Could work 7 days in a row at and come in under their 88 hours. I don't know why somebody would want 7 days in a row. I don't know why a hospital would want to request a person to work 7 days in a row, but we do have these rules with respect to how much time is allowed off for vacations during each period or 2-week period or so on, hours averaging agreements. This is a true or false question. That's false, because in Ontario, overtime generally begins at 44 hours. We have this day of rest situation, 11 consecutive hours and time of rest. 11 consecutive hours must be off each day in each 24-hour period. So in other words, we have to give people time off in between their shifts. Because of the way that things work, it's hard. The legislation is written weirdly, but you could be going from an afternoon shift to a day shift. So 8 hours off between shifts, 11 hours off per day. So usually when you think 11 consecutive hours off is important, but it could be at the beginning or the end of the week. And so they write the legislation to say, yep, there has to be 8 hours off between shifts and 11 consecutive hours off each day. And no matter how you end your week, start your week, end your day, start your day, what time of day, whether it starts at midnight or 4 o'clock in the afternoon, we get it covered with the 11 and 8 rule. And I mentioned days of rest. So we have these things called hours averaging. In Alberta, it's interesting because hours averaging in Alberta is a little bit more flexible generally than it is in other provinces. And I don't know the history of this, but I attribute it to camp work, people heading out to oil rigs. So they got to fly them in and they have to fly them out, and there's a lot of cost and inefficiency and all kinds of things. And so, for example, in most provinces, you have to have 1 day off for every week. In Alberta, it says you have to have 1 day off every week, or 2 days off every 2 weeks, or 3 days off every 3 weeks, or 4 days off every 4 weeks. And so what that means is that you could go into camp, for example, and work for 3 weeks and 3 days, come home for 4 days, then go back for 3 weeks and 3 days. And that would be allowed if it's written into an employment agreement, known in advance, the employee agrees to it, and it's part of your regular policy. In a lot of provinces, we've got things called a special permit, where you have to take those special agreements and send them to the Minister of Labor and ask for permission, because they can get abusive if they're not handled properly. We've got overtime rules in Ontario, 44 hours per week. And then if a person works, say, on Saturdays as the supervisor, and they work Monday to Friday as a regular employees, but they get promoted to supervisor on the weekends, companies used to try to say, no, you're a supervisor, and bosses, management are entitled to overtime. And the government has set a 50% rule on that one. And now they no longer have, was Bill 148, they no longer have the 50% rule. So if you're regularly a full-time regular employee who's covered under the Employment Standards Act, you can't work 1 shift a week, or sometimes as a supervisor. You're either the full-time supervisor or you're not. And if you're not the full-time supervisor, then the Employment Standards Act applies to you. BC's got some interesting rules. Let's take a look at this one. And again, I don't need you to memorize this, but this is to prove and to show to you that different provinces tackle the same issues in different ways. So in British Columbia, you get time and a half. They've got the 44-hour rule. And then also they have got the 8-hour rule. So if you work in any given day, now an employer can define a day, midnight to midnight, say, for example, they've got if you work more than an 8-hour day, you get time and a half. And if you work more than a 12-hour day, you get double time. So in this particular example, the worker worked 8 hours on Monday, so they got regular pay on Monday. They worked 10 hours on Tuesday, so they got 8 hours of regular pay on Tuesday, and 2 hours of time and a half because they worked a total of 10. And on Wednesday, they only worked 6, so it's all regular. But on Thursday, long day, 8 hours of regular pay, 4 hours up to 12 at time and a half, and 1 hour at double time, only actually having worked 37 hours in total during the week, so didn't hit the 44-hour threshold yet. We see this person has worked, 8, 24, 30 regular hours, and 6 overtime hours, and 1 double time hour. And so the province of British Columbia approached the problem in a different way, saying, yeah, we don't only want to protect workers who work more than 44 hours, but what if they get these weird shifts and things? How do we address that also? So again, different provinces, different rules. In the province of Ontario, you cannot request a person to come to work for less than 3 hours. In the province of Alberta, 3 hours. Interesting enough, in Ontario, it was 3 hours for like 20 years. And then when the Liberal government looked like they were going to lose the last election 6 years ago, Kathleen Wynne passed a whole bunch of modifications to the Employment Standards Act, changed it to 4, changed a whole bunch of other things also. Doug Ford, the Conservative premier, ran on a policy that he would repeal a lot of those things. And so he repealed the 4 back to 3 again, and repealed other things too, which I'll probably get into in other examples through here. So all provinces have special rules for young people. All young people 13, 14, 15 years of age must complete the Young Workers Readiness Certificate in Manitoba, for example. There are, and this is typically, those have to do with safety issues. There are restrictions on young people 13, 14 years of age, for example, in Manitoba, on special things like they cannot work in construction, they can't work on drilling rigs, they can't work at heights more than 1.5 meters, they can't work with pesticides or up scaffolding or pruning and maintenance. So different provinces have different rules and pay levels for young people, and it's important to know that age is one of the things that there can be variations in the employment standards legislation, and also industries tend to have some variations in the standard employment standards, in the regular employment standards. Equal pay for equal work has to deal with the gender differences. So generally, most employment standards legislation deals with male and female workers performing exactly or substantially similarly the same job in the same location with the same standards of work and expectations, the same amount of tenure, that it is illegal when all things are the same to pay men and women differently. There is this complicated, it's not complicated, there's this long sort of test process for equal work that exists. This example is from the province of Ontario. So is there a difference in pay between two people? You go, okay, we'll move on to step number 2. Is there a difference in their gender? Oh, yes, that person got paid this much, that got paid that much. So when we move on to step number 3, are they required to perform substantially the same work at the same place, use the same skills to perform their jobs, make the same amount of effort? If the answer is yes, they're all the same, you move on to the next step. If the answer is no, any one of those things are different, one's working at the Brampton plant, the other one's working at the Markham plant, then you can't use equal pay as a reason to argue that people should be paid the same work, you have to pay the same, you have to use some other argument, but this piece of legislation, part of the legislation, won't apply. And then, of course, they ask more detailed questions like, is there a seniority system, a merit system, commission systems, status of tenure, years of work, all that kind of stuff. And then if there is no difference in those, then a company would be in violation of the law if they were paying men and women differently. What almost happened in Ontario in 2018, so this is the story I was telling you about Kathleen Wynne and the Liberal government implementing a whole bunch of legal changes with hopes that it would improve their popularity and they would get reelected. They introduced amendments to the employment it wasn't even called employment equity, it was called equal pay. And so what they were going to do was they were going to say that regardless of who your employer is, regardless of your employer's status, whether you're a part-time worker or a full-time worker, that full-time, part-time worker, and casual workers must all be paid exactly the same, doing the same job. And then they went further to say temporary help agencies who are supplying replacement workers must also get paid exactly the same as the person they're replacing. Well, if you think, even though we love the temporary staffing services industry, that a temporary worker who shows up for a week can do the same job as the person who sat there for 52 weeks, and that they should be paid exactly the same amount of money for all kinds of reasons, that I think that's very flawed thinking. And so this is an example of what almost happened. And I don't really include this because this certainly won't be part of the test for your examination for the challenge exam, but it's put there to show you that changes to employment legislation are done politically by your legislature, and they are done with the expectation that they are good for society, good for workers, maybe good for employers, maybe good for the economy, and especially good for their political status and popularity. And sometimes all of those issues don't necessarily align, which is why it's important that we are paying attention to what our political elected representatives are paying attention to and what they're saying and what they want to accomplish. And is it good public policy or is it popular public policy? And maybe we want popular public policy. Maybe we don't. So this is just given to you an example to show you how these changes are made and what can happen. In pretty much every province, you can have written agreements for employment, whether it's through temporary help services, between an employer and an employee at a temporary service or in a regular company, that supersede the standards that are better than the standards set by employment standards, or at least on balance, the combination of changes are better. So you can have, for example, an hours averaging agreement in a province where you average it together for 88 hours instead of 44 for overtime. But you also might say in that agreement, the employees might say, yeah, and I also want to get my vacation pay paid on my individual paycheck. I don't want to wait for it to accrue until I take my vacation because I'm a temp and I come and I go. And so you can put into the agreement that everyone agrees to that, yeah, they'll not get paid overtime until 88 hours over a 2-week period. And that might be to the advantage of workers because the customer might have 12-hour shifts. And so it's hard to not go into 48 hours in a 4-day work week without going into overtime. And if we had to pay overtime, the customer wouldn't use us. So we average at 88 over 2 weeks, and we get under 88 hours with the 7-day work, 7 days over 2 weeks. And they also, so that could be part of the agreement. And the other part of the agreement might be that they get paid 4% vacation. So we can have written agreements so long as they are considered to be better or equal to, and very often require the approval of the director at the Ministry of Labor if they're significant enough that they need some approval. So these hours averaging agreements, I've talked at length about those. We won't spend more time on them. Alberta's got hours averaging agreements up to 4 weeks. In terms of lunch breaks, they're often written into the legislation. In many provinces, a 30-minute break must be given within every 5-hour period. So if you've got an 8-hour workday, person starts at 8 in the morning, 9, 10, 11, 12, 1, they need to be given by law a 30-minute lunch break or eating break before 1 o'clock in the afternoon. And then, of course, they come back at 1:30 and they work until 4. 5 hours haven't existed, so we've got no obligation to give them another break. Things like coffee breaks, 15-minute breaks in the morning or in the afternoon, or when the coffee truck shows up, those are not written into the law. Those might be a company policy and a company practice, and they might be perfectly acceptable and desirable, but they're not part of the minimum legislation. So it does not require, the employment standards does not require any additional breaks for coffee runs or additional breaks in lesser than a 5-hour period. In most provinces, we have vacation breaks that are 2 weeks of vacation for every year of employment. Most of the time has to be already worked and accumulated or accrued on a prorated basis before a person can take it. Companies can legally make you work for a full year before you could take your 2 weeks vacation within the next 12-month period. Most companies don't do that. Most companies will allow people to take their vacation on a prorated basis. So they start in January, then they take a month off or a week off in July because they've worked for 6 months, and then they take a week off at Christmas because they've worked another 6 months. A lot of companies allow people to borrow against their vacation. So they work for a company for 6 months. They take 2 weeks off in the summer. So they've borrowed a week that they haven't actually earned yet. That's perfectly acceptable. That's between the employee and the employer. It's just that they cannot make it less than 2 weeks per year for each hour of work. The legislation typically stipulates when it has to be given. It will also allow for you to have a written agreement to pay money in lieu of the time off. Although a person still is entitled to have the time off, the only difference is the person says, hey, I want to take my 2 weeks vacation here, and you approve the 2 weeks vacation or the 1 week here and 1 week there. If they got paid on every check, then they don't get any money when they take the time off. In Ontario, one of the things that Kathleen Wynne did before she got elected in Bill 148 in 2018 was that she increased vacations to mandatorily 3 weeks after 5 years of employment. Other provinces, she wasn't groundbreaking there. Some other provinces have the exact same legislation. So it becomes 6% of wages after 5 years or 3 weeks after 5 years. Let's move on. So we want to calculate vacation pay. It's pretty easy to do. Typically what you do is you just take the average of what their daily pay or weekly pay is. So if you worked on a part-time basis and had wages of $16,000 in an entitlement year, then the person is entitled to 4% of $16,000, which is $640. And so when Susan takes her time off, she can get her check for $640. Now, it doesn't really matter how much the person earned in each week, or whether that was all at once, or whether that happened in just the last 4 weeks, whether she earned her $16,000 and earned $4,000 a week. It's all based upon a percentage of earnings. Now, public holidays, often called statutory holidays, in Canada, again, are set from each province. And I think I may have talked about that earlier, where Saint Jean Baptiste Day is in Quebec and Remembrance Day is in Alberta, and Family Day was added to Ontario about 10 years ago, which is in February. And so we've got, let's see if I can do this top of my head, in the province of Ontario, we have got New Year's Day, Family Day in February, third Monday of February, Good Friday, not Easter Monday, Good Friday in the month of April, May 24th weekend, Victoria Day in the month of May, which is usually the third Monday in May. We've got Canada Day, which is July 1st. There's this thing in Ontario called the civic holiday, which occurs on the 1st of August, which after years and years of 35 years of being in the business and teaching this course for forever, I don't understand it. It's not written as a statutory holiday. It is a holiday. People understand the civic holiday to be a holiday that people are entitled to have off. A lot of the rules around public holidays apply. Most companies treat it just like a public holiday and they pay people for their time off. You're not obligated under the law to pay for the civic holiday. But you are obligated under the law to pay people time and a half if they work on the civic holiday. So it's a weird one and doesn't really count as a public holiday, but it is an anomaly in the province of Ontario. That anomaly doesn't exist in other provinces. Of course, we've got Labor Day, which is the first Monday of September. And October, we've got Thanksgiving, nothing in November, and then December, we've got Christmas Day and Boxing Day. And so these public holidays, think about it, Christmas Day, Boxing Day, and New Year's Day all happen within a 7-day period. So 3 out of our 10 public holidays, 30% of them, all happen in literally one pay period, or depending upon when and how your pay periods end, possibly 2 pay periods. And so when you're operating a temporary help business, if your people only work for you in December and the first part of January, you don't have the rest of the year to make all your money to pay for those 3 paid days. So you literally could bill for 4 days and have to pay 3 people for time off. So it's there's some business management decisions, but there is an obligation to pay under the law. The calculation of those public holidays is, sorry, I forgot to turn my ringer off. The calculation of those public holidays is pretty simple. We take the 30 days immediately preceding the 4 pay period, 4 weekly pay periods or 2 biweekly pay periods, immediately preceding the pay period in which the public holiday is paid in. Well, so it's July 1st, it's usually how much money did you make in June, that sort of thing. And we take that and divide it by 20 or 5%. And that gives us an average 1 day's pay. So if you think about it in a 4-week period, in a 30-day period, or a 4-week period, there are 4 weekly pay periods. In those 4 weekly pay periods, the average person works 5 days a week. In those 5 days a week, that means that there's 20 work days. So if we take the amount of money that a person earned in those 4 weekly pay periods, then and divided by 20, we get 1 average day's pay. So if you're a temp and you happen to work 3 days a week at 12 hours a day, then you actually are only working 3 days a week, but getting 36 hours. And so we take that 36 hours and we divide it up to figure out what 1 average day's pay is, and it works out pretty normally. Very often, if a person's working an odd schedule, they are not scheduled to work on that day. And sometimes they are scheduled to work on that day. And if they do work on the public holiday or scheduled to work on the holiday, they get paid a day's pay. Even if they're not scheduled to work on that holiday day, they get paid a day's pay using this formula. If they do work on the holiday, they get paid time and a half for working on the holiday, plus the day's pay. So you've heard the expression, colloquial, general term, oh yeah, I get double time and a half for working on the holiday. You're not really getting double time and a half for working on the holiday. You would have got the regular time for sitting at home, and you got the time and a half for going to work. So that happens to work out to be, in most cases, double time and a half. But the reality is you're getting 1 public holiday pay day for not working, and time and a half for working works out to 2.5. So in this example listed above, the interesting thing here is this. Megan finished a 6-month assignment on May the 26th. That should say June the 26th. Oh, no, May the 26th. So on May the 26th. And Canada Day is 5 weeks later on July the 1st. And Megan earns $15 an hour. She was available to work on May the 30th, but didn't get an offer to work on May the 30th, and didn't work between May the 30th and July 1st. Because she was not actually terminated, she was considered to be laid off. So when you're laid off, you're considered to be employed. So we take all employed individuals, we take the amount of money that they earned in the 4-week periods immediately preceding the holiday. The 4-week periods immediately preceding the July 1st holiday happened in June, but she didn't work in June. So in Megan's case, her regular wages during that 4-week period were zero, and her vacation pay was zero. So we divide that by 20, and she earns zero. So it doesn't mean she wasn't eligible for pay. It means that her calculation turned out to be zero. Whereas in Erna's example, Erna worked for 4 weeks in June prior to Canada Day public holiday with a total regular wages calculated at $120 per day or $600 per week over a 5-day period. She worked in those 4 weeks for $2,400. Erna earned $2,400 in the 4-week period. And so we take her $2,400 plus any vacation pay that she might have earned. She didn't earn any. And we divide that by 20, and it works out to be, lo and behold, her average day's pay, $120. So in the case of Erna, she did work during those 4-week periods, and so we could do the calculation. Now, if a person had taken 2 weeks off and received their vacation pay, then we would include the vacation pay in the calculation. Here's an anomaly. Let's say we have got a, let's say we have got an employee that has agreed to receive, a temporary worker, who's agreed to receive their 4% vacation pay on every check. So what we do is we calculate the entire amount of vacation pay and public holiday pay. No, sorry. We calculate the entire amount of the regular pay, not the vacation pay. And we calculate what their regular day's pay would be. And then we add 4% onto it. So we pay them vacation pay on their public holiday pay. So we calculate their regular wages. We calculate, we calculate their vacation pay. I said it wrong. They calculate their regular wages. We calculate their vacation pay. We add it all up and divide it by 4. And then when we pay them their public holiday pay, we give them vacation pay on top of that, because our employment agreement says we're not going to withhold money for your vacation or time for your vacation. We're going to pay you out on each check. So even though it was public holiday pay, it's still qualified for vacation pay. Manitoba public holiday pay has a different example. Worker consistently works for the same number of hours, gets 1 regular workday's pay as a general holiday pay. For example, an employee who also works 8 hours a day, 40 hours a week would get their regular 8 hours as general holiday pay. So same thing. For employees whose hours are inconsistent, regular wage people get their average regular wage. People who work varying hours, say on temp or part-time, we calculate 5% of their gross wages in the 4-week period. So incidentally, in Ontario, we divide by 20. In Manitoba, they say give them 5%. Well, if you know math, divide by 20 is 5%. So it's the same calculation, just expressed differently. And this is very often the kind of things that we see in the differences between provincial legislations. Somebody over there decides, I don't like the way that was worded. It could be misinterpreted. And so they reword it to get the same outcome. So in this particular case, Manitoba says, pay them 5% of their wages in the 4 weeks immediately preceding the holiday. In Ontario, we say, take the amount that they earned in gross earnings preceding the 4 weeks and divide it by 20. Same number. Public holiday pay for Jordan. Jordan ends a 6-month assignment. And I got something on my screen here. I got to move it out of the way. Jordan earns a 6-month assignment on Friday, February the 17th. He's been earning $800 a week while on assignment. Family Day falls on Monday, February the 20th. He's offered another assignment that begins 1 week after Family Day on February the 27th, which he accepts. So we have this thing called the before and after policy. And so the law says that a person must work their regular work day, scheduled work day, before the holiday and their regular scheduled work day after the holiday in order to be eligible to receive their pay. So you got a public holiday coming up and you play hooky, you skip out the holidays on Monday and you skip out on Friday and don't show up for work and take an extra 4-day weekend. Your employer's not happy. Sorry, guys, working from the house today and forgot to turn off all my phones. So they work in the 4 weeks prior. They normally would get an average day's pay, but they skip out on Friday and are not therefore entitled to receive their public holiday pay because they did not work their regular scheduled work day before. Now, in this particular case, where Jordan is not scheduled to work until a week after the holiday ends. In other words, there's no assignment available and is not offered a job. But the next scheduled work day is February 27th. It's not the Monday immediately following the holiday. But the law says that you have to work your next scheduled work day, not the next calendar work day. And so in this particular case, Jordan did come to work on Friday and did come to work on Monday, the February the 27th, then Jordan would also receive the $3,200 divided by 20, $160 for the public holiday, for staying home on the public holiday, even though Jordan was not scheduled to work, but did work the the regular scheduled day before, which happened to be on the Friday, and the regular scheduled day after, which happened to be a week later on February the 27th. So there's the calculation again for Jordan. I'm not sure why I have it in there twice. If a person works on a public holiday, they get paid their time and a half. They get paid their regular time plus time and a half for working on the holiday. Hence, down here, the colloquial expression, double time and a half. And again, let's see what time it is. I think it is 2:39. Okay, so before we move on to the next topic, we're going to take our 10-minute break. It is 2:40 right now. We're going to come back at 2:50, and then we're going to carry on for an hour and 10 minutes. I'm going to freeze the screen on this screen right here. And if you guys want to stay on mute and come back in 10 minutes, we'll see you then. Okay. There is a question, are IT professionals exempt from overtime pay in Ontario? And the answer to that question is yes. And we have a screen coming up that is going to address that issue specifically. So welcome back, everyone. And I'm on my presentation stopped. So give me a second here. Let me try to figure this out. And my computer is frozen. Sorry about this, guys. Maybe we should stop recording for a second there. Not waste any time, and I'll see what I can do about getting this going again. All right. Hopefully we're back in business here again. And if I can get somebody to just acknowledge for me that you can hear me, and we're back on the termination and severance screen. I just flipped it. We're good?
Yes, yeah.
Okay, sorry. Okay, thanks, guys. Sorry about that little blip there for a second. Because I am having some, I'm not sure, some temporary internet problems here. So somebody jump in and yell at me if something goes wrong here. We're going to talk a little bit about, by the way, we're going to go really quickly through the next session because the beginning part where I explained to you the different types of laws and jurisdictions on the laws, those all take a lot of time. But now I think you've got the point that there's a lot of different topics that are covered under employment standards, but every province is different. And I've given you lots of different examples to show you that when the topic exists, it's probably pretty important for you to look up what is current because of the political nature of the way that these decisions are made in our legislatures, and that they can change from province to province and time to time. We talk a lot under employment standards around termination and severance. And I first want to just sort of address the notion of the minimum employment standards with respect to termination and the common law standard with respect to termination. So when we talk about the minimum standards under the ESA, the Employment Standards Act, this is where the government tells us how much notice a person is entitled to if we intend to discontinue their employment for any reason other than cause. We won't go into cause too much, but other than cause. So if you're just slow in business or things aren't working out or, whatever, then, variations in your business flows, and a person's going to be terminated, they are entitled to a period of notice that is based upon the number of years that the employee has worked for the organization. The longer number of years, the longer notice period. We can also, in most cases, give a person pay in lieu of that notice. So we can say, hey, we want to give you 8 weeks notice, but geez, we got to shut her down now. So we'll give you 8 weeks pay. You can go home today or tomorrow. And so we're entitled to give people pay in lieu of notice or some combination of pay in lieu of notice. So we could say they're giving you 8 weeks notice, but I only need you to work for 2 to finish up a few things, and then we'll pay you for the other 6 to go home. So it can be a combination of both. The calculation is based upon how much a person earned during the previous 12 week period prior to. So a person might have been earning more money in the most recent 12 weeks or less money. These time periods can affect, it's not how much you earned over the last year, but it is how much you've earned over the course of the last 12 weeks or 3 months. There's some variations if it's going to be a temporary layoff or a permanent termination, but every province is a little bit different there. And when we're going to calculate those weeks, then we got to take into consideration whether the only count the weeks where a person was able to work or not able to work, that they were available to work. If they refuse to work, then we don't count those weeks. And there are some other, if a person was suspended, we don't count those weeks. So there's different rules with respect to the determination of weeks. So this is a true or false question that says the Employment Standards Act termination notice is based upon the total number of years an employee has been employed with a staffing company, not just the assignment with the customer that they have recently just completed. And the answer is yes, true. It has to deal with the number of years that they worked for the temporary company, not for the customer. Listen, in most cases, lots of cases, the majority of cases, a person might work for a long period of time, a year or longer, with one customer. They never worked before with the agency. They didn't work after. But that's not necessarily the case. I mean, we've got workers that have worked for us for 10, 12, 15 years, and they continue to work for a whole variety of different customers from week to week, month to month, and period to period. And unless employment is specifically and officially terminated and then restarted again, the number of years will count from the beginning of time the person started to work for you to the time that they ended. So it's possible that a person worked for us for 2 years, and then at the end of their 2 years, we terminated employment. And then a year later, they came back and started to work for us again. That's considered to be new employment. But in the case where a person goes away for a few months or a few weeks, then comes back and then starts and stops, unless there's an official notice of termination, we have in our industry the notion of continuity of employment, which means that a person continues to be actively employed even during times of inactivity or work. So it's like a layoff. It's like they're being laid off. So their tenure doesn't stop accumulating during the layoff period. It's counted in their years of tenure. Now we got different lingo for different provinces that are almost exactly the same. So we say that a person who's worked less than 1 year in Ontario is, whether it's 1 week or 3 months or 6 months or 9 months or 11 months, they're entitled to 1 week's notice. In British Columbia, you must have worked 3 months or longer and up to 1 year in order to get their 1 week. In the province of Ontario, if you worked for 1 year or longer, but less than 3, so in other words, you worked 2 years, you worked into your second year or completed your second year, just completed your second year, then that's considered to be 2 years, 2 weeks. In Alberta, they say after 12 months, you're entitled to 2 weeks. After 3 years or more, you're entitled to 3 weeks. So you can see that this really works out to be 1 week per year, but the wording is slightly different. And you got to take a look at it to try to see how they've worded it. But it tends to work out to be 1 week per year, with the small difference of Alberta and British Columbia, Ontario being you worked for any period of time, and British Columbia being after 3 months. So there's some examples. Manitoba, let's take a look at Manitoba. We popped that one in there just to show you another difference. So you must have worked at least 30 days, not 90 days in Alberta in order to qualify. At least 1 year, less than 3 for 2 weeks, and so on. Most of the provinces cap it out at 8 weeks. So if you worked 8 years or longer, then the notice period for termination is 8 weeks, but not longer. Now, the terms severance and termination are often used by lawyers and by people when we're talking about common law, are often used interchangeably. Whereas in the provincial legislation in Ontario, and it is the only province that differentiates on the terminology, we have 2 different types of pay that are given to people when they're terminated. If an employee has worked for 5 years or longer with the same employer, and the employer has a payroll size in excess of $2.5 million per year, or if they're laying off or severing 50 people or more, so they could have a smaller payroll but terminating 50 people at a time, then we have to pay termination pay 1 week per year and severance pay 1 week per year, up to 8 weeks. Now remember, the termination pay is really notice, 8 weeks notice, 6 weeks notice, 5 weeks notice. But we could give them money in pay in lieu of that notice. So remember the example, we're going to give you 8 weeks notice, but I only need you to work for 2. So please work for 2. If you complete the 2, I'll give you the other 6 to go home. That is a combination of pay and pay in lieu of notice. Whereas severance pay is pay. So if a person worked for you for 5 years or longer, and we terminate, so if they've worked for 5 years and we terminate them, we owe them 5 weeks notice or 5 weeks termination pay in lieu of notice. And we owe them 5 weeks severance pay. So the terms termination pay and severance pay are different under the Employment Standards Act. Now, in common law, this is when an employer or an employee has breached their employment contract. It's nothing to do with employment standards. And of course, the employment contract has to be the minimum of the Employment Standards Act or better. So a person signs an employment agreement and they come to work for 5 years and they get terminated at the end of 5 years. A lawyer might say, oh, you're entitled to 5 months pay. And I'm seeing a lot of flashing on my screen here. So somebody jump in, just let me know you're okay. You're good to see all this. So a lawyer might come in and say, oh, you're entitled to 5 weeks pay. Okay, I don't see anybody jumping in to tell me they can hear me.
I can hear you.
Okay, so you can. Okay, so I'll ignore the flashing on my screen. I don't know what that means. I do have 2 internet connections into my home office, but the reason I have 2 is because Bell and Rogers are not always the most reliable sources. I apologize if your screen is flashing or if I'm freezing. And so a lawyer might say in common law, oh, geez, they've unlawfully dismissed you. This was an unlawful termination. And they don't mean that it was a breach of the Employment Standards Act. What they mean is that the contract, under contract law, that we had an obligation to provide more. And possibly in common law, we had an obligation to provide more. So a lawyer typically is not used when there's a violation or a severance under the Employment Standards Act, because you don't need a lawyer for that. You just go and get paid. You go and complain and they enforce the payment. But if you want more than that, then a lawyer might step in and say, this is a violation of common law responsibility or a breach of your employment contract. They'll call it unlawful dismissal. And they won't differentiate between severance pay and termination pay. As a matter of fact, they may not even differentiate between unpaid vacation pay. What they do is they go in and they say, all right, we've got 3 weeks of unpaid vacation pay. So there's 3 weeks. We've got this overtime pay that you never received for working on the public holiday. So that's $1,000 or $2,000. We want 2 weeks per year for every year that you work. So there's 10 more weeks of pay. And we want, this is a gross violation of your employment agreement. So we want another 2 more weeks in a penalty, which works out to be a month. And they might give you a number. And then the 2 parties negotiate on the number. They don't necessarily have to break it down into individual pieces the way the Employment Standards Act would break it down into individual pieces, because the Employment Standards branch will be looking at all the various pieces of the legislation and how they apply, whereas a lawyer under common law might say, this is a violation of contract, what's it worth? So we know that in common law, the standard is typically higher than employment standards law. I mentioned different times leave from work. I think I did. In crops, we've got different kinds of leaves like pregnancy leave, personal emergency leave, family medical leave, family caregiver leave, critical illness and childcare leave, organ donor leave, reservist leave, if the person gets called to be in the reserves, crime-related or child death or child disappearance abduction leaves. Every province has their own standard. A leave does not represent paid time off. A leave means this is time that you can take from your employer because this thing happened, and you're entitled to have unpaid time off without risk of losing your job. They're not like public holiday time or vacation time where you get paid for that time off. Leaves are protected employment where you have to leave your employment and you have to be guaranteed your work back when it's done. So Ontario added back when, in the same circumstance with Kathleen Wynne under Bill 48, added pregnancy loss leave, added a family medical leave, child death leave for up to 2 years, and crime-related disappearance leave. And we also added domestic and sexual violence leave, 13 weeks. So if you are the victim of domestic violence or sexual violence, there's time off for that. And this new personal emergency leave, which is 10 days of my apologies, which is 10 days of time off and 2 days paid if the employee has worked. So this is the only one, the personal emergency leave. We have to go and take a look at the definition of personal emergency leave in order to determine what qualifies there. But in that particular one, it's the only one where they have legislated 2 paid days or any days paid. So we have different provinces have different standards. I put in an example here for Manitoba, just so you can see there's owner-donor leaves, there's leave for critical illness, death or disappearance of child. Here's one, leave for citizenship, for new Canadians to receive their certificate of citizenship. You have to work for the company for 30 days and you can have a half a day off without pay to go get your citizenship. Quite frankly, if I had an employee taking a day off to go for their citizenship, I'd at least give them the day, and I'd probably make sure I paid them also. But that would be an employer decision to offer something above and beyond the minimum standards. So these periods and time periods and definitions will differ from province to province. I left this in here. We're not going to spend any time on it, but this is an example of the kind of things that people can do with respect to reforms to the Employment Standards Act. In Ontario and other provinces, they introduced the COVID income protection benefit. So when people were off with COVID, they had their jobs protected for a certain number of days. And in Ontario, they came up with the mechanism where employers could pay the worker their time off, and then the employer could get a reimbursement from the Workers' Compensation Insurance Board. So instead of the person applying for workers' comp, they said, look, just pay the person's normal and let the company get the money back from the workers' comp. Because the Ontario government doesn't have a mechanism, like unemployment insurance is a mechanism run by the federal government. The Ontario government doesn't have a mechanism to pay people payroll money. And so in order to tax things properly and to keep things going, the Ontario government said, okay, let's get people a couple days pay, 2 days pay if they go off on, some companies have sick day benefits and all kinds of stuff, and they far exceed the standard. But lots of companies had no minimum standard, none whatsoever. So they made it the law, and they said, hey, look, you got to give people 2 days off with pay on their first instance of COVID, and we'll let the company get some money back through reimbursements through the Workers' Compensation Board, because there is a financial relationship that exists between companies and the Workers' Compensation Board, because we're paying to them and they're giving us rebates all the time. And then from March 1st, 2020 to July 30th, 2022, a union employed with a temporary, a non-union employee with temporary reduced or temporary eliminated work for reasons related to COVID is deemed to be on job protected unpaid period. So they created a new leave type, so you couldn't terminate a person because you closed down or reduced their hours. They were considered to be laid off, and that time period went on until July 31st, 2020. And so all of these things also with respect to companies having to give notice and pay of lieu of notice, they were all suspended during that period. So companies didn't have to give notice or pay in lieu of notice to people who were temporarily laid off until July 31st, 2022. Interestingly, though, there were a number of court cases and they're ongoing. People who were laid off during that period and then didn't get called back on July 31st, 2022, or weren't called back yet, then there was a question as to whether or not now the layoff period kicked in, or whether how that was going to be handled, especially if those people went off and got new jobs during their layoff period and were not eligible to come back to work or didn't make themselves available to come back to work. So there's all kinds of issues that arose from that. In Ontario, we now have a requirement for a written policy on disconnecting from work. So employers with 25 employees or more on January 1st of 2022 were required to put a policy in place that said that, hey, when you're off from work, you're allowed to turn off your phone. When you're off from work, you're not required to answer your emails or your text messages. And so there's no specific thing that says what that policy has to be, but it does say that you must put that policy in writing and the employees have to agree to it. And that way you can't fire a person or have unreasonable expectations or, deem cause that people were non-responsive. You have to give people a right to disconnect from work when they're not officially on the clock. Ontario also introduced Bill 88, which is the electronic monitoring policy requirement. So if a company has any kind of electronic monitoring policy, so that could be video cameras in the office or around the building, that could be GPS on your phone, that could be track my computer, find my phone, find my computer. It could be GPS on a vehicle or on a car. In the home care company that I own, we've got a thing called GPS fencing, which I'm sure you're aware of. So we know that a person is on site. So when they show up at a customer's location to their home, we know they're at their home. They can't clock in, enter notes, do stuff unless the GPS says that they're there. And this is all fine and dandy. It's all legal, so long as we fully disclose what our policy is and how people are being monitored so that they can make choices to not be monitored when they're not working, and then they go into it in an informed way. So this is not overly for us. It's pretty respectful legislation. They also introduced licensing of temporary help agencies and recruiters in Ontario. So lots of provinces, Alberta, British Columbia, Manitoba, Quebec, all have licensing arrangements for employment agencies, recruiters. None have licensing requirements for temporary staffing companies. The presumption is that temporary staffing companies are employers and that the Employment Standards Act and every other law, human rights, pay equity, employment equity, every other law that exists, workers' compensation, that exists to protect employees is appropriate and will protect temporary help workers. In Ontario, they've decided that temporary help agencies are inclined to take advantage of the uniqueness of their relationship and possibly exploit workers, or simply there is just a miscommunication and misunderstanding of that unique relationship. So Ontario introduced a whole bunch of, starting in 2011 and continued to do it through to 2018. And then now in 2023, legislation concerning licensing of temporary help services. So in 2011 in Ontario, they abolished licensing of employment agencies in Ontario for good reason. And it just wasn't being effective and it wasn't being monitored and managed properly. And then in 2022, they decided they were going to reintroduce employment agency licensing. And it was to come effective January 1st, 2024. The regime is actually open now for people to make applications. And every employment agency, recruiter, and temporary help service. So for the first time in Canada, temporary help services are going to be required to identify themselves and become licensed. Now there's some provisions. For example, there's a $750 fee to get a license. There's a requirement for a $25,000 bond or line of credit that needs to be signed and set aside by your bank to cover any unpaid wages that might be. So what they're concerned about is that the customer pays the agency or the temporary staffing service and temporary help service, and the TSA doesn't pay the workers, and so they want to have a $25,000 bond there so they can go and take the money out of that bond and pay the workers on the agency's behalf. They don't want the company to have to pay twice. Although there is also legislation, which was Bill 18, I'll come to it later on, that has got, it's called joint and several liability, that even though there will be this licensing bond and the money, $25,000 of the bond will be available, the customer will still be responsible for the payment of wages to the worker if the agency does not pay it. So we've got provincial licensing in these provinces. I listed them before, and I got down here this link to Fiera Foods, which just last week won a multi-million-dollar CRA suit over HST payments. So here's an interesting story that in 2011 to 2014, Fiera Foods, who's the largest supplier of croissants in Canada, maybe the world, specializing in baked food, but specializing in croissants. Fiera Foods used 15 different temporary staffing services, paid incredibly low rates, sometimes rates lower than minimum wage. And these 15 temporary staffing services, some of them seem to have some unusual relationship. So, you know, the workers could work for agency number 1 on Monday, and the same workers would come back to the same assignment, but be invoiced under agency number 2. And then the same workers would come back on Wednesday, but be invoiced under agency number 3. And so my presumption is that these unscrupulous employment staffing services were setting up separate companies so that they, and not treating them as related, so they could keep their total payroll under $1 million, I think it is, so that they could exempt themselves, $1.5 million, so they could exempt themselves from paying employers' health tax, and that they could keep employees' hours under 44 hours a week, so they could work, 12 or 15 hours a day working for one agency, then work 12 or 15 hours the next day for another agency, and never get into the legally paid time and a half after working for one employer. And of course, the employees are being paid terribly, sometimes less than minimum wage. They don't know that they're being denied their right to getting paid time and a half for hours over 44. And the customer never asked any, or didn't seem to be, to care about this. All they cared about was low wage workers, and they would easily comply with the payment to 4 different agencies for the same workers during the same week. So Revenue Canada said, nah, this was a employment relationship. You were just using a third party, and then you were funneling HST money to them so that you could take the input tax credit. And Fiera Foods won the tax argument with the government, the courts saying, yeah, they supplied all the documentation. They had written contracts. The companies that collected the HST had HST numbers. They were legitimate companies. It's up to, even though you think something untoward was going on, it's up to the Revenue Canada to go collect the money from those unscrupulous companies, not from the buyer who paid those unscrupulous companies. And so this was an interesting case. And the reason why I'm telling you the story is because the new licensing arrangement would make sure that those employment agencies or temporary staffing services would have a employment agency or temporary staffing services license. And you cannot get a temporary staffing services license without being in compliance with Revenue Canada. And by the way, if anyone is on the line, Susan, Sukram, or anyone else who I can see is not on mute, can you please mute your can you please point down in the bottom left-hand corner of your screen and mute your microphone so that we don't overhear your
Yes,
conversation?
so I thought you normally.
Okay, so much for that. The
My.
and so the example I'm giving you is about employment agency licenses. A couple things. Number one is the agencies will be required to submit information proving that they're in good standing with Revenue Canada and that they don't have criminal offenses and that they meet a bunch of standards. Secondly, they'll have to pay a $750 fee in order to get their license. Third, they'll have to get a bond or a line of credit that is assigned specifically to the Ministry of Labor to help pay for unpaid wages or other violations. And the customers under a separate legislation have shared liability to make sure that those workers do get paid. And finally, under the new licensing regime, customers in Ontario can be fined for using employment agency or temporary staffing services that is unlicensed. So it will be the obligation of the customer to ask if the agency has a license and an obligation of the agency or staffing service to prove that they do have a license. And customers like Fiera Foods, if they were to repeat this case again, and if those staffing services were paying under minimum wage or not in good standing with Revenue Canada, as they're not, they would be in violation of the new law. So the application for licensing in Ontario requires certain information about contacts and email addresses of the owners, the locations where they will be operating in and out of Canada, not just in Ontario. It will require information about the corporation partnerships and corporate officers. It's going to require information with respect to those corporate officers that they don't have criminal offenses. And again, if I just could kind of step out there for those of you, Susan or anyone else who have not got their computers on mute, could you please, well, I can mute you. There we go. Let me just kind of roll through this. Sorry, guys, I didn't realize that I had the authority to mute people out. So now we've done that. Information about the people who will be running the businesses to make sure they don't have criminal offenses. And of course, the tax compliance verification. So there's a process now that you can go through with Revenue Canada and the Ontario Ministry of Finance to get a certificate of tax compliance. So anybody who hasn't paid their EHT, hasn't paid their taxes, hasn't paid their withholding in payroll taxes, they will not be able to get their license. So the presumption is that under this new licensing regime, that unscrupulous operators, who of course are not members of ACSESS, those kind of companies don't join ACSESS. We don't let them join ACSESS because we go through this similar process with them anyways in order to become members. Those companies are now going to get shut out, or easier to get shut out, because companies that use them will realize that all there has to be is a complaint from a worker saying I didn't get paid, and they'll go take a look at it and they'll say to the customer, prove that you're dealing with a licensed agency, and the licensed agent, if they're not, they're going to get fined, and then they're going to go find that agency, and if they're not licensed, that company is going to get fined and they're going to get shut down. And so, you know, there's always going to be chasing the fly-by-nighters, but this will at least make it very, very difficult for companies to continue to operate in an unscrupulous fashion, bringing harm to the reputations of all good companies like ours in the industry. The Employment Standards Act also includes harsh penalties for things called reprisal. Reprisal is the term when a company, an employer, reaches out toward a employee who complained about their rights and then got in trouble for complaining about their rights. So if an employee said, hey, I worked 46 hours last week, I think I was supposed to get 2 hours of overtime because 44 hours is the time and a half. And the employer says, hey, look it, you complain about that. I got lots of workers who can work for us. We don't need people complaining about those little things. Be a team player or else you're fired. That's a reprisal. And that is dealt with in a harsh fashion. The Minister of Labor, usually their intent is to make things right. But when there's a reprisal, they have the ability to issue harsh fines for companies that are knowingly unabiding by the law and threatening people who try to ask about their rights under the law. I'm not going to spend a lot of time on this. The answer is 5 years. We've got an obligation to retain records for most things for 5 years or longer. There's a couple things that are 3 years for record keeping. We must keep for 3 to 5 years from the last date of employment. On most things, we have to keep vacation records for 5 years. We have to keep employee names and leaves and all kinds of stuff. I'm not going to go into it for which law is which and so on, but for things like unemployment insurance, Canada Pension Plan, wages, employment standards, human rights, there's a difference in some different laws between 3 and 5. So just hang on to your data for 5 years and be on the right side of that in case somebody ever makes a complaint or asks a question. And so record keeping, for example, in the province of Manitoba is like even different. That we have to keep records of the date that employment started, and we have to know the date of birth and the occupation and the wages and the reason for each deduction. So lots of information needs to be kept. Now in Ontario, it's the only province that is codified or written into the statute. In the other provinces, it's common law. The definition of a temporary help agency. So in the law, they define it assignment employees or employees of temporary help agencies to have the right to, so they define them. Then they say they have the right to public holidays and public holiday pay and notice of termination and severance and notice of termination of assignment and a right to equal pay, and that we can't charge them fees, and we cannot prevent a temporary worker from getting a job from our customer. So we can't put anything in the agreement, say thou shalt not apply for a job with our customer, thou shalt not take a job with our customer. We cannot charge fees to our customers after 6 months. So we can still charge a fee to a customer for a recruitment fee if it's written into the agreement for recruitment. But once the assignment worker has been on an assignment for 6 months or longer, doesn't matter if it's full-time, part-time, doesn't matter if they worked for 1 day 6 months ago, 6 months after the first day of their assignment, it is illegal in the province of Ontario for a temporary staffing service or an employment agency to charge a fee to that employer. I mentioned earlier joint liability under Bill 148, which was an amendment to the Employment Standards Act, which says that the customer and the agency or temporary staffing services have got joint responsibility with respect to those employees. Bill 2014, Bill 18, so change the agency recruitment. Oh yeah. So in 2014, there were all kinds of provisions entered to the Employment Standards Act with respect to the recruitment of foreign nationals and also to workplace health and safety. This part also created a joint liability between the customer and the staffing service so that the regular wages and overtime pay were all covered, and that if the agency refused to pay, the customer would be forced to pay. By the way, most provinces and most countries have got special foreign national legislation. That special foreign national legislation talks about temporary foreign workers and people who are in the country on permit, giving special rights and privileges to those people so that they can not be taken advantage of through either one, their ignorance and lack of knowledge about the laws, or two, their vulnerability for fear of being deported from the country. And so we have got special protections under foreign national laws, and many provinces in Canada require, for example, in Nova Scotia, you don't require an employment agency's license, but if you are recruiting foreign nationals, you require a foreign nationals recruitment license. So they really heightened the awareness around that. So Bill 18 was passed for lost wages not paid by staffing services, and therefore the customer would have a shared liability toward the payment of those wages. The question that was asked earlier in the Q&A, I see another question down in the chat section. I'm going to look at it right after the screen. Effective January 1st, 2023, so just this year, it's a good question. The question was, are IT professionals eligible for overtime pay over 44 hours? And the answer is that it's effective January 2023, if specific criteria are met, they're no longer, that the Employment Standards Act no longer applied to employees who are business consultants or information technology consultants. So if they're employees, the answer is yes. And if they are paid as a contractor or through a temporary staffing service, the answer is no. They're not entitled. So certain conditions have to exist, but if they are consultants or business consultants or information technology consultants, then they don't apply. So the question is, why would a company want to employ IT people and pay them time and a half? Well, instead of getting consultants when they could avoid all of those obligations. Well, the answer is they very often make them managers. They very often pay them a salary. They very often don't monitor their hours closely, and they let them come into work late, work from home, go here, go there. So companies have got ways to work around it. And it's possible, could be challenged, that they say that their employee who haven't met the conditions and so forth, they are eligible, but there's lots of wiggle room now for IT consultants, especially through staffing services, to not get paid time and a half for time worked over 44 hours. Keep in mind also, there's nothing stopping you as a temporary staffing service or an employment agency from negotiating a contract with your customer that they pay time and a half. You can always pay more than what the law requires. You just can't pay less. So it's important that we are in compliance so that we nurture our relationships with our employees and our customers so that we can be profitable. So let's just skip all this. There are employment standards posters that are available in most ministries, Ministry of Labor, in most provinces, and there are brochures and folders, and most provinces require that you either post these posters on the wall in a visible place, put them on your website, or make those brochures available to your employees so that they can understand what their rights are. And the posters look kind of like the ones that are here. And now we have got special posters and notices and brochures for temporary help agencies. So each temporary help agency should have a stack of these things on file to give to temporary workers when they apply for jobs. Does an employer does not need to consider age as a factor? Well, we talked about that. The answer is yes, they do have to consider age as a factor because there are special considerations for people under the age of 16 and 14 and 15 years old in most provinces. So the employment standards branches in each province typically do this. They provide posters, they provide fact sheets, they give catalogs, they offer videos, and they have websites, and they've got Q&A, and they've got interactive online tools for calculating overtime and calculating public holiday pay, and they offer workshops and seminars. And so they're helpful. Most ministries of labor are responsive in helping people to comply. They also, in some provinces, and particularly in Ontario, where one of the governments that was in power for about 14 years, kind of took a little bit of a hate on for employment agencies and temporary staffing services. So they started to do surprise audits, and they would show up at staffing services firms, making them to prove their employment records about minimum wage and about posters and about overtime pay, and make that they're keeping their records properly and so on. But the Employment Standards Act is mostly investigation complaints driven. So they tend to not, with the exception of these occasional surprise audits that they shoot out at various industries, staffing services and agency industry being one of them. They typically are responding to a worker or employee's complaint that they got fired or they lost their job or they didn't get paid properly. And they respond to that complaint. And it is normally the behavior of the Employment Standards Branch, although they don't promise it, that they don't use a complaint to launch a broader complaint. So in other words, if you were to complain to the Employment Standards Act that your employer owed you vacation pay, they typically would not use that complaint to launch an investigation to find out whether or not that's a problem with everybody. I mean, of course, if that was the case, then everybody would lose trust in the Employment Standards Branch in being a partner in compliance and training and sharing. And they'd say, every time we talk to these people, they come and investigate us, so we're not going to talk to them anymore. So that's generally not the problem. Okay, give me 2 seconds here while I click on this little chat down here. Yeah, so there's somebody telling me there, if I had read it earlier, that I can mute out the people who are not muted out. So thank you. So the next question is, sorry, just to confirm, did you say that a staffing service firm cannot charge or bill a client for a worker that has been employed for over 6 months? I did say that, but I'll repeat it more clearly. Number one, we cannot put into our employment agreements or act in any way that would unfairly influence a temporary worker from seeking their own employment. In other words, we can't threaten them that we'll sue them or something if they apply for a job or fire them or something. That's number one. Number two, we can have service agreements with our customers that say that they will pay us a recruitment fee if they hire one of our candidates within 6 months of that candidate's first date of a temporary assignment with that customer. So if we can say, oh, you have to pay 20% of their salary or 50% of the gross margin or some prorated amount of, 26 weeks or something. You can have some type of service arrangement and agreement with your client that they will pay you a fee if they hire your temporary workers. However, it is now, since 2014, against the law in Ontario for an employment agency to charge a placement fee to a customer after 6 months from the first date that temporary worker was introduced to the customer. It doesn't matter if they worked full-time. It doesn't matter how many hours. We used to have these try to buy, temp to perm contracts. Once you reached 800 hours, there's no fee. There's a $2 per hour for every hour under $800 or something. I don't know, but I'm just making up numbers. But now it doesn't matter how many hours. That might be the calculation that you have if they hire the worker within the first 6 months. But once you hit 6 months from the first date that the worker was sent to that customer, it is no longer legal to have a contract to charge a fee for that person. So in other words, what the government was saying is, we think that temporary staffing is a wonderful vehicle in order for people to get exposure to employers and to employment and to opportunities to learn new skills, but it's temporary. And so if you're going to write a contract that imposes fees, creating a barrier to employment for a worker forever, and you keep them employed forever because the customer sees the fee as a barrier, then when temporary is over, let's call it what it is. It's permanent. And if they want to keep the person on temporary employment forever, that's fine, but let's remove the barrier from permanent employment. Now, interestingly enough, this doesn't apply to independent contractors. So if you've got an IT worker or a business consultant who legitimately meets the definition of an IT business consultant or IT consultant and is not an employee, they are not subject to the Employment Standards Act because they are not an employee. They've given us leeway now to deem them as not employees. And so you could charge a fee. But the issue is, are they an employee or not? If they are an employee, the Employment Standards Act applies, and the prohibition on charging fees after 6 months applies. If they are an IT professional or a business consultant and they meet the conditions to not be considered an employee, then the Employment Standards Act does not apply because it only applies to employer-employee relationships, and you can keep that provision in your contract to charge a fee to your customer. So hopefully that answered that question. Okay, so we're going to talk a little bit about this notion of co-employment, and we're going to zoom through it pretty quickly because we kind of really have dealt with this in a roundabout way all the way through this presentation. Co-employment is this notion that an employee or a worker can have a tripartite or a three-part employment relationship with two employers, one being the staffing company and one being the customer. Now, in common law, most of the courts have decided that the staffing company is really the employer. And in statute, the Ontario government has written right into the law that the staffing company is the employer. However, they continue to go both ways because they've also said, even though the staffing company is considered to be the employer, we're going to have a joint and several liability under the bills that I've already told you about, where the customer remains responsible for unpaid wages. So is the customer the employer or not? And the answer is, it's a co-employment relationship. Under the basic concepts of the law, the first employer will default automatically to the staffing company. And if the staffing company is egregiously inappropriate and does not pay people, withholds wages, or violates aspects of the law, they can hold the customer responsible for that. So they're saying to the customer under the Employment Standards Act, you've got a responsibility to make sure your staffing company is good and they do the right thing. And if not, at the end of the day, you might be held responsible also. Now, that's fine and dandy under the Employment Standards Act because the Ontario government has codified it, written it into statute in the Employment Standards Act, and some of the other provinces have made it very clear in common law decisions in court that the staffing company is in fact the employer, and they don't even bother to write it down into the statute because it's very clear that they're the employer. And whoever is deemed to be the employer is going to have to comply with the Employment Standards Act. So the worker's not really being denied their rights under the Employment Standard Act. The question might only be who's the primary employer. And most of the time, in most provinces other than Ontario, where it's not written down, common law court decisions have decided temporary staffing companies. But I say but again, because when it comes time for things like workplace health and safety, everybody knows that the customer has got absolute discretion and control over the safety of their work site. They decide whether there's guards on saws. They decide whether or not people can sit on a forklift truck and have appropriate license and training. They decide whether or not people wear protective gear and equipment, and the temporary staffing company isn't there, doesn't provide that equipment. They're not eligible or able to even manage and supervise that. And so even though in the Employment Standards Act, they've tried in Ontario, they have in Ontario codified it, and they've tried in other provinces through common law to get court decisions that establish that, there continues to be workplace health and safety, human rights, employment equity, workplace violence, harassment, protection, a plethora of laws that relate to employers and employees that still can deem and do deem the customer to be the employer for some aspects of their employment relationship. So we have this tripartite employment relationship. This is why unions often go out and get temporary workers to sign registration cards. They try to get temporary workers to vote to determine whether or not they're going to be unionized. Whether or not the union agreement actually includes temporary workers and protects them or not, they try to get the temporary workers to sign the union cards in order to form the union. Because the courts have decided sometimes a co-employment relationship exists and the customer is, for some aspects of the law, the employer. So we need never assume that only one party is responsible. We must always assume that even when it's codified, there's going to be joint and several liability legislation written, or there's going to be common law decisions that put responsibility on both the staffing company and the customer. Yeah, so you cannot just go out and hire a temporary staffing service and say, oh, all of our liabilities with respect to safety just disappeared. All of our liabilities with respect to workers' compensation just disappeared. Oh, all of our liabilities with respect to discrimination and human rights just appeared. We'll get them to discriminate on our behalf. That will never happen because of co-employment responsibilities. So this three-part relationship, I don't have to stay on these screens for very long, but here are some examples. The staffing company discussed the pay rates and other compensation, and they have time submitted to them, and they onboard the employees to the client, and they might be the person who has to go in and remove assignment employees or fire them or terminate them or take them out of the assignment or fire them from the agency. They have to discuss extensions, and they call people up and say what their hours of work are going to be, and they counsel on performance. And yet the customer is providing the job specific competencies to the agency. They're defining the work, and they provide the workplace culture and the environment, and they oversee the workers, and they provide training to these contingent, temporary, and part-time workers, and they supervise these workers, and they determine who they're going to report to, and at what location, and what work they're going to perform. And they work through security on site, and they keep employees safe on site, and they have some payroll equipment on site. Like, for example, in my company, in one of my companies, our employees are all paid through an app that doesn't matter if you're the customer's employee or our employee, the time rolls up to us and we find out what your hours are in order to pay you. So, I had other customers where they go onto the time clock, and we drill in through the internet into the time clock at nighttime, and we download our hours of our temporary workers. So the temporary workers come in and they punch in too on the same time clock that the customer's employees punch into. All these things make the customer look like they're the employer. We're just a payer. So the temporary workers get confused because they go back and forth from different employers, providing different aspects of the employment-employee relationship. So we've got to try to find balance in that relationship by mitigating our risk, but trying to be very clear up front and in writing to the employees about what our obligations are to them and what the customer's obligations are, and what we expect from the employee in terms of their responding and reporting to us. So things like schedule time to meet your customers and your employees to discuss these things. And other than work your employees we have to also be considered about what other activities happen on site, like where do they get their lunch? Do they get compensation for uniforms? Or are they invited to parties? We got to be concerned about not just about the performance of task. We got to talk about getting paid on time. And so does the customer sign off on the timesheet so that we can pay our employees on time? So communication in this partnership is critical to ensure that there's good understanding by all three parties about who does what. And so we also have to think about our customers. And, they might now start requesting for adequate proof of the staffing services insurance, but they also might be asking now about the staffing company's license. in Ontario, or in other provinces they already do. They sometimes, customers are going to be asked to be additionally named insured on insurance policies. So in case one of the temporary help workers drops an anvil on the Wile E. Coyote's head, whose insurance policy is going to cover that accident? Request a review from the Staffing Services annual report. So it's not going to be uncommon for your customers to say, let us see your financial statements. We want some assurances that you're able to financially meet your obligations so that we don't have to pay through joint and several liability in the future. They're going to be asking you for references and request executive summaries, and staffing service executives. They're going to want to know who works for you and who's running the place. They may want to come visit your office, and they might want to learn about all of the things that you do in order to retain your employees and keep them happy. So they're going to ask you to meet on a regular basis. And guess what? As a professional staffing service company, if your customers are not asking you to do this, you should be offering it to them. If you offer this to them and you say, here's our employment agency license, here is our financial stability report, here is a review of, come on over to our office and see what we do. Then before they go ahead and hire some other unreputable temporary staffing service just because they beat you by 50 cents an hour or by 4% on a placement fee or 2% on a placement fee, they might think twice because they see with their own eyes how important these issues are. What answers contribute to co-employment in the workplace? Your customers set pay rates and hours. Sure, of course they do. Sometimes they tell you, you pay them this, we pay you that. They definitely set the hours. Your customers training your employees and generating reports and doing analysis. Your customers counsel your employees on being tardy and coming back from lunch and what time they show up for work and their attendance. And your customers invite your employees to their annual Christmas parties and to dress up for Halloween. All of these types of things contribute to a co-employment liability. I'm not going to go over this joint liability thing. This one has to do with drink tickets and a customer having a party and the employees not getting the drink tickets. And of course, there's the other issue of the customer giving your employee drink tickets and letting them drive home. And then who's going to be responsible for the drinking and driving car accident and injuries that occur. So these are all issues that we need to be concerned about with respect to co-employment. So we've got joint and several liability under employment standards. We've got joint and several liability under workers' compensation and hazardous materials under WHMIS. We've got step card checks for unionizations. That's that issue of them voting to become part of the union. We've got issues around who's going to pay termination and severance. So if the customer just walks in and fires your employee on the spot, who pays for that? We've got human rights legislation. What happens if your customer is being constantly violating human rights and offending your workers? We've got employment insurance, CPP, tax withholding, and other issues. We've got contract law. I could go on. Determination of employees versus independent contractor. Are they treating your employee like an independent contractor? Or even worse, are they treating a legitimate independent contractor like an employee? So openness, honesty, and transparency are the solution to this. We need to educate our workers. Now, there's this thing called elect to work. I just want you to know it's not a thing. It used to be a thing. There used to be provisions in several employment standards legislations across the country that said if an employee has the right to elect to work or not to work when requested to do so, then they are exempt from the Employment Standards Act. This terminology, elect to work or not to work when requested to do so, was code for temporary workers. And it's been eliminated pretty much everywhere. So if you ever hear someone say, oh, that doesn't apply to that person, they're an elect to work employee, say wrong century. That is no longer an issue. Temporary workers have got employment relationships, usually almost always first with the temporary staffing service. There are co-employment relationships and tripartite relationships that exist in all kinds of legislation, laws, and contracts. So be aware. Elect to work employees are so named because, yeah, well, we're going to move on from that. It's not a thing because it's been removed. Fees for hiring temporary workers. We talked about this. Not allowed. Your client can hire your temporary employees at any time. They can charge a temp to firm. You can charge a temp to firm perm fee so long as it happens during the first 6 months. Your client may also provide a reference letter for your assignment employees. There's nothing stopping your customers from providing references. There's lots of links that are included in the bottom of the presentation for you today. You guys have all got printouts of it. We are 5 minutes to 4. I now will invite you to, please, if you wish, to take yourself off mute and jump in and ask me some questions or ask for some clarity on things that we talked about today. Okay, so guys, it is not uncommon that at the end of our sessions, I don't get any questions. And it is not uncommon for people to really keep themselves on mute and not ask questions. And I always assume that's because our presentation is just so awesome that, of course, you could not have a question that you'd like to ask. But I know better. I know that's because half of you have left and you're gone and you've left your computer on. Some of you have gone to sleep. Some of you are multitasking. That's okay. I wish that you didn't do that, but that happens on these long presentations. So please, if you didn't listen to the whole thing today, then review the presentation again online when you get the link. Number 2, if you have any questions whatsoever, my email address is I have lots of different business email addresses, but they all merge to one place. So just go to that one place. Steve.Jones, STEVE.Jones, JONES @Bell, that perfectly unreliable internet provider we had today, .net. Steve.Jones @Bell.net. Please send me your question. I'm glad to answer your question separately. If it's a super awesome question, we will protect your identity, but we'll get the answer out to everyone so that they can get a super awesome answer. Also, want to remind you that we've got another session tomorrow. So those people who are on tomorrow, we're going to go quickly at the beginning because a lot of the first slides about the different levels of government and other things are the same, assuming that you didn't take this one already. So we're going to zoom by that. If there are people that attend tomorrow that didn't attend today, then they're going to have to go and listen to today's session to catch up on that information. And also, I want to remind you that, which I'm just going to find it here. I have it in my email.
Steve, this is Gupna. While you're just finding, I just had a question regarding the overtime pay. I just put it on the chat too. Are IT professionals exempt from overtime, like time and a half?
The answer was given during the presentation, and the answer is yes, sometimes, usually. If you treat your IT professionals as consultants, then they will be exempt from the Employment Standards Act entirely, which exempts them from the provision for overtime. So I'm not, because this is new legislation this year, and it hasn't really been publicly and widely contested, it's possible that your customer can have IT employees and not treat them as consultants, and they still would be eligible under the Employment Standards Act. But you as an agency or a temporary staffing service or a contract agency have the right to treat your IT and business consultants as independent contractors and to exempt them. If you don't take the steps to delineate them properly as an IT consultant and independent contractor, then in my opinion, at some point in time in the future, somebody might contest and test this new change in the law. So in other words, the new change in the law effective January 1st, 2023 says that you can exempt your IT contractors and business consultants. They call them consultants. IT consultants and business consultants from the Employment Standards Act. Under certain provisions, there are exemptions. And I know what the provisions and exemptions are going to be. That if you treat your IT consultants like employees, you make them absolutely indifferent from your employees, you might be setting yourself up. So if you're
But if these are incorporated, they have their own business.
Then they're exempt. Then they're absolutely exempt.
So they are independent contractors, then they are not.
Yeah, for two reasons. Number one is that they were always independent contractors with their own independent companies and deemed to be so. So they were exempt anyways. And to remove any confusion, a new amendment was made to the law in January of 2023 that says those people don't bother fighting with us. They're exempt. So the only people that may not be exempt are people that you treat exactly like employees. In other words, they don't have a company. They're not incorporated. You give them business cards that say that they're your employee, you know, and it's more likely that your customer is going to screw up on that, not you. That your customer is going to treat their own employees like employees. Not you.
Okay, perfect. So,
Okay.
So if we hire everyone as, just thinking of different scenarios and different perspectives. So if we, as a temp help agency, if we hire independent contractors like their own corporation, then they, as per whatever ESA or whatever the new rule, and if they are IT professionals, they are considered independent contractors then.
They must be IT professionals or business professionals. So don't bother doing with call center representatives or marketing people or administrative assistants. You won't get away with that.
So only if they are IT, then it's fine.
IT and business consultants.
IT and business consultants. Perfect. That's helpful.
Which, by the way, you could probably extend that to technical contractors like engineers and stuff like that. You know.
Yeah, like the software developers and cybersecurity.
Yeah, and like I said, and like engineers and architects, designers. So they could be technical architects, engineers, people building bridges. You would call them business consultants.
And where could I read this in the ESA, this specific thing from January 2023 that's come in effect?
I'd have to go look at. I just know that it exists.
Maybe I'll email you, and then you could guide me.
Yeah,
there.
I could find you the reference point. That's not a problem. Yeah.
Okay, perfect. Thank you so much. That's helpful.
You're very welcome. You're very welcome. Okay, so any other questions? That was a good question, by the way. Any other questions? Okay, so I also want to remind you that you want to put in your calendars for May the 8th to May the 10th, 2024, ACSESS will be holding its national conference in Toronto. This will be the only national conference specifically designed for our industry, for recruiters, employment agencies, temporary staffing consultants and recruiters, contractors. The content over the 2.5 days will be specifically designed for recruiting consultants, employment agencies. You can go to other conferences and see salespeople. You can go to United States or Vegas or someplace and go to a big industry conference. This will be the only national industry conference available in Canada next year. It is fantastic. It is the place where you make contacts, where you learn, where you improve yourself, where you start to understand more and more and more about the business. They don't even have registrations yet, but I want you to put those dates of May the 8th to the 10th for Toronto in your calendar. as we move towards the beginning of the new year, when you get 5 months in advance, start looking for notifications for registration. If you're an owner or an operator, you know that this is a tax deductible expense. If you're an employee, go ask your employer or your manager whether or not you can go. If they say no, then try to convince them why you should. And you might even want to set up some competitions inside your company so that certain people who perform at a particular level get rewarded by going to the conference. But this is the place to be. And so put that on your calendar and you'll start to receive notices as a CPC designate and participant of things like this going forward. Hopefully you received an email today at 1:30 concerning that conference.